I'd now like to talk to you about the offence of criminal damage, which is an offence against property contrary to Section 1.1 of the Criminal Damage Act 1971. There is an aggravated form of the offence, which we will look at later in the tutorial. Criminal damage is an either-way offence, but it is unusual in that if the damage is under £5,000, it will always be tried summarily. If it were to be tried on indictment, the maximum sentence is one of 10 years imprisonment. A person is guilty of criminal damage where they, without lawful excuse, destroy or damage property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property is destroyed or damaged. Breaking it down, the offence has 5 elements. The Actus Reyes is to destroy or damage property belonging to another without lawful excuse. Let us now look at each element in turn. Destroy or damage. The damage need not be permanent. However, in the case of A, a juvenile, and R, it was held that the damage must be more than merely trivial or nominal. In this case, the defendant spat at a police officer. The spit did not cause a mark. What constitutes damage is a matter of fact or degree, and where damage can be rectified, but it causes expense or inconvenience to do so, damage may be held to have occurred. This approach was followed in Samuels and Stubbs, where the defendant stamped on a police officer's cap, which was later pushed back into shape. The cases of Lloyd and DPP and Mitchell address the same issue and are similar in their facts. In both cases, the defendants damaged wheel clamps which were placed on their cars, and both were convicted of criminal damage.